watching Fox 35 News Plus, streaming on Fox Local.
Well, I played the wrong open, but welcome to Florida Live. I'm Garrett Wymer, and we appreciate you joining us here on this Wednesday afternoon, live on Fox Local, fox13news.com, fox35orlando.com, and also on YouTube. We've got a lot ahead of us here on this afternoon's show, including, let me give you a live look inside a courtroom in Osceola County, where Stephan Sterns is due back in court for a second straight day. Again, you see the judge inside the courtroom. This is for a suppression hearing. Stephan Sterns, the man, of course, charged in with the sexual battery and murder as well of Maddie Soto, 13-year-old who went missing. This is a suppression hearing to block evidence collected from Sterns' phone and his Google account. So this is Stephan Sterns here sitting at the defendant's table inside that courtroom. The defense says investigators unlawfully seized and searched that phone, while the prosecutors say Sterns gave consent, that evidence was properly obtained. You can see the shackles around his feet as he wears that orange jumpsuit, where he has been in custody for a while now, facing these charges. It's about 60 counts, I believe, in this sexual battery case. This is the case that's set to go to trial May 5th. This is the case that is the subject of this hearing today, this suppression hearing. Now, he is also charged with capital murder. That case set to go to trial in September. So this is just getting ready to get underway. We are monitoring it. We will likely check in again on it in just a few minutes. But first, I want to start with something in Tallahassee, where this morning on the floor of the Florida Senate, an emotional tribute from lawmakers as they honored the victims of the Florida State University shooting just a few days ago in Tallahassee. They also recognized several visitors in the gallery, including survivors not just of the Florida State shooting, but FSU students who also survived the Marjorie Stoneman Douglas shooting back in 2018. I want to play for you that emotional moment on the Florida Senate floor earlier today.
Last Thursday, my FSU family I knew this day was coming, and was rocked by senseless violence on our campus, with 6 students being shot and 2 adults being killed. Today I rise and ask for a moment of silence for my Seminole family as we mourn those lost and the many lives that have been changed forever.
Please rise in a moment of silence and remembrance of those that were lost in this tragedy. Thank you.
And in that moment, you can see a number of lawmakers go over to State Senator Corey Simon, console him, put their arms around him, pat him on the back. Before here, in just a moment, you're going to see Senate President Ben Albritton also call a recess and go over there and console him as well.
We'll stand in formal recess. Senate will be back in order. For those in the gallery, what you just witnessed was beautiful and the best the Florida Senate has to offer. Amen, sister. Amen. Senator Polsky, for an introduction.
Thank you very much, Mr. President. I'm very sad to say that we also have some students here from FSU who witnessed the shooting. They are part of Students Demand Action, an advocacy group that is working for common sense gun reform. I wanted to introduce 4 of these women: Stephanie Horowitz, Bailey Hirschenow, Peyton Apple, and Haley Rabinowitz. If you could please stand, they're over, I don't know which gallery that is, West Gallery. In particular, I wanted to talk about Stephanie in the gray shirt, wearing a Marjorie Stoneman Douglas high school t-shirt. She was a freshman on February 14th, 2018. She was in the building next to the shooting. She was in the student union on Thursday when the shots rang out. No one should have to live through one mass shooting. No one should have to live through 2 mass shootings. I am so sorry for what you've been through, and I wanted an opportunity to introduce you all and to talk about the important work that Students Demand Action is doing, and I hope that you all get a chance to meet with them and the group Moms Demand Action. They're working really hard for all of our safety. Thank you so much for being here. So sorry for everything you've been through, and welcome to the Florida Senate.
We want to get you live now inside this Osceola County courtroom as this hearing gets underway. Stephan Sterns was just sworn in, about to testify during this suppression hearing. So let's go ahead and listen in.
Thank you. Any cross requested?
Yes, Your Honor.
Thank you. Ms. Spinell?
Can I have just a moment?
Yes.
Mr. Stearns, you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Acosta on February 27th. Is that correct, of last year?
That is correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, as Acosta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Briefly, when she told me to input my PIN because it had locked itself.
And Detective Tagler actually mentioned looking at your history, which you okayed, correct? Okay. Your Honor, can we approach?
Yeah, come on up.
You hear the discussion there. At the center of this is the question of consent and whether Stephan Sterns consented to the search of his phone. We apologize for the audio quality there. Obviously, very overmodulated. Not anything that we can do on our end here. But it looks like they may be working to try to address some of those issues. But let's go ahead and keep listening in.
The phone in question was in fact your cell phone.
Yes, it was.
I don't have any other questions.
Thank you. Any redirect? Thank you. Argument, state.
Well, the hearing is going to continue. It appears that Stephan Sterns' testimony has come to an end. Very brief there on the direct and also on the cross-examination as they discuss whether the evidence collected from his phone and Google account can be used going forward. We're going to continue to monitor this, but we are going to go ahead and take a break here on Florida Live, and we'll be right back. Welcome back into Florida Live. I'm Garrett Wymer, and thanks for joining us on this Wednesday afternoon live on Fox Local and on YouTube. It is time now for our Tampa Connection, and for that we go to the newsroom of Fox 13 Tampa Bay and digital content producer Nancy Gay, who is joining us live. And Nancy, good to see you.
It's good to see you too, Garrett. We're going to start today with a deputy-involved shooting that took place around 7:30 this morning down in Brandon. Now, according to the Hillsborough County Sheriff's Office, multiple people called 911 around 7:24 a.m. to report a man walking down a busy street who is carrying a fully loaded assault rifle while dressed in tactical gear, including a bulletproof vest as well as a full communication headset. Now, Deputy Chief Joseph Maurer said that 3 deputies went to the scene, and when they were there, they commanded the suspect multiple times to drop his weapon, but he refused to put it down. And at 7:38, which is a little more than 10 minutes after those 911 calls started coming in, the 3 deputies opened fire on the suspect. That suspect was taken to an area hospital and pronounced dead. Now, just a few moments ago that we learned that the suspect has been identified as Vincent Tyler Morin. Now, Deputy Chief Maurer said that Morin is actually not a convicted felon. However, he has been arrested in the past for misdemeanors, including trespassing as well as possession of marijuana. The 3 deputies who shot Morin include one with 35 years of service, one who's been with the Hillsborough County Sheriff's Office for 1 year, and one who's been with the agency for about 6 months. Maurer said that none of the deputies involved have shot a suspect in the past. Now, at this time, it is unclear why Morin was walking around dressed like that while carrying a fully loaded assault rifle. But Deputy Chief Maurer says that he did not have peaceful intentions.
Else, driving your children to school and seeing that man there. Also, look, just to my left, busy business complexes. I've got Lowe's right here. I've got multiple shop centers over on this way. This was a dangerous situation.
Now, Fox 13 does have a reporter on this story, and we'll have much more information later on tonight. Garrett?
All right. Also following a story from the campus of USF.
Yes, that's right. Yesterday, police say students found an empty 9mm cartridge in a parking lot. Now, this discovery was made just days after an empty gun case as well as empty ammunition magazines were found in the Fine Arts Building. Those items were found on Saturday at the University of South Florida. Now, this 9mm cartridge was found in parking lot 9. Officers were able to recover the cartridge, and the ATF swept the surrounding area but did not find any additional items of concern. As of this time, it is unknown who the cartridge belonged to or how it got into the parking lot. However, university officials say there is no active threat on campus. And on Monday, police said that officers have increased their presence on the campus of USF following last week's deadly shooting at FSU. Now, USF police are asking anybody who sees or hears anything that is out of place to please contact authorities immediately. Garrett?
Yeah, certainly a concerning find, coming in so quickly on the heels of what happened last week. Finally, story number 3 here, and this is a very Florida story, if there ever is one.
Yes, this is very Florida, and it's a very good story. An eagle is recovering after a Lakewood Ranch man rescued him from a pond. Now, this Lakewood Ranch man actually swam 100 yards into a pond that he knew had an alligator living in it to save this bird over the weekend. Doug Hayes said that he was sitting in his living room with his wife on Saturday when they heard a crash. They looked into the lake in their backyard, and that's when they saw an eagle in the middle of the water with another eagle circling overhead. Doug said that he knew eagles cannot swim, so he ran outside, ripped off his shirt, tossed his flip-flops, and dove into the water. And before he dove into the water, he also threw his phone on the ground, but his wife picked it up and captured the rescue on video. Now, Doug, who is 70 years old, says he loves animals and didn't even think twice about the 7-foot alligator who calls that lake home. He said that once he got to the eagle in the middle of the lake, he grabbed for it, and that's when the eagle jumped on his forearms with its talons, leaving him with some minor injuries. Doug also said that he barely made it to shore because he was pretty tired after swimming 100 yards out and 100 yards back. However, he said he monitored the eagle for a few hours before it was taken to the Wildlife Center of Southwest Florida, which is in Venice. The eagle is in stable condition, but did suffer a deep wound close to the thoracic cavity. Now, experts say for the next few weeks, the primary focus will be on pain management and antibiotics to fight infection. And after the eagle recovers a little bit more, he or she will have physical therapy to help it fly again. Now, the head of the Wildlife Center of Southwest Florida said that while she is glad that the eagle was saved, she does want people to think about their own safety before jumping into action. Doug says that he always saves animals whenever he can and has no regrets about saving this eagle.
That would be in my head the rest of my life, I couldn't save this bird, so I had to do it. I just wanted to get the eagle and save it, because it's our national symbol. It's freedom. It's America,
Now, as I mentioned, that eagle will be on pain medication as well as antibiotics for the next few weeks, and then hopefully it will begin physical therapy to learn to fly once again. Garrett?
Absolutely incredible. I am telling you what, especially when you factor in that he knew there's an alligator that lives in that water.
Yes. He said that he saw that eagle. He wanted to help it. He wasn't even thinking about that 7-foot alligator that lives there. He had one goal, which was to save that eagle, and that's exactly what he did.
That's pretty cool. All right. Fox 13 digital content producer Nancy Gay, we appreciate you joining us for our Tampa Connection.
Thank you.
We're going to take a break, and we'll be right back. Welcome back into Florida Live. I want to get you back inside this Osceola County courtroom where a suppression hearing is going on in the case against Stephan Sterns. This is the case where he is charged with several dozen counts of sexual battery, images, a number of things relating to 13-year-old Maddie Soto. He is also charged with her murder. That is a separate case. But this suppression hearing to block evidence that was obtained from his cell phone, from his Google account, that the defense says was improperly obtained, that illegally searched and seized. And so we heard from Stephan Sterns himself earlier in the show saying that he did not give consent. And so now we are hearing from a number of investigators on this case. This is a detective with the Orange County Sheriff's Office talking about her interactions with Stephan Sterns. Let's go ahead and listen in.
And then almost around noontime.
Yes.
Thank you. Overruled as to leading. I've got a question. The times that you just gave were for identifications of the tag through the LPR system.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
Did you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes.
Your Honor, I'm approaching the witness for the record with Detective Tagler's 11-page narrative.
Thank you. I'm looking at page 4.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on a tag reader going in and out of St. Cloud?
Yes.
What times was it traveling towards or into St. Cloud?
This is eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Sterns in this case?
Yes.
Were you aware as to who the last person to have seen Maddie Soto alive or have seen her was?
Yes.
Who?
Stephan Sterns.
Was that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Miss Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Sterns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that
Yes, Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephan Sterns?
Yes.
How did you know who was Stephan Sterns and how to find him in the area?
Detective Hunt pointed him out.
Was your encounter with Mr. Sterns audio recorded?
Yes.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Sterns?
I am not.
How about Detective Louis Acosta?
Same, not in uniform.
Does anybody approach Mr. Sterns with you and Detective Acosta?
No.
Where is Mr. Sterns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable to communicate with you?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Sterns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stephan Sterns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acosta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Sterns' path of travel impeded by either of you?
It was not.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
Questioning continues inside an Osceola County courtroom as they talk with Detective Myra Tagler, an investigator with the Orange County Sheriff's Office. You see Stephan Sterns there sitting at the defendant's table, leaning over, speaking with his attorney, who's a public defender, representing him in these cases. He is charged in 2 separate cases, including the sexual battery and the death of 13-year-old Maddie Soto. We're going to take a break here on Florida Live. We are continuing to monitor developments inside the courtroom. We're going to step aside for a couple of minutes, and we'll be right back. Welcome back into Florida Live. I'm Garrett Wymer. Thanks for joining us on this Wednesday afternoon, live on Fox Local and on YouTube. The FAA says it is working on efforts to increase the pipeline of air traffic controllers. We've talked before about the air traffic controller shortage. There have been discussions of that when it comes to near misses and other air traffic catastrophes that we have seen. And so part of that effort to increase the pipeline and increase the number of air traffic controllers is to accelerate the hiring of air traffic controllers from programs at approved universities. And so today we heard from several students and also faculty at Embry-Riddle Aeronautical University because they have a number of students who are on track to be that university's first graduates to bypass the FAA Training Academy and head directly to FAA facilities. So they are now preparing for testing in a lab, state-of-the-art, newly upgraded as well at Embry-Riddle. And so we heard today, I want to play for you a couple of officials from the university talking about the current situation when it comes to air traffic controllers and how programs like this can help address the problem.
I think we've all heard that there's an air traffic control shortage, air traffic controller shortage, and I'm here to tell you that is real. The situation has the potential, and I say the potential, to decrease our safety margins and impact the efficiency of our national airspace system. The program that we are unveiling today is a program that will help alleviate some of that shortfall. As mentioned, I was a part of the independent safety review team appointed by the acting FAA administrator. We produced a report November of 2023. And we were here to examine the air traffic control system and to make recommendations. And one of the areas that we looked at was controller staffing. And our report noted, and I'll quote from the report, the understaffing that currently exists places additional strain on the system, further eroding the margins of safety and increasing risk. Now, don't let me give you the wrong impression. Our air traffic control system is safe, and it's safe because the FAA mitigates those risks by reducing capacity, but that also impacts the efficiency of the system. When there's a lack of sufficient air traffic controllers to staff all positions to manage the throughput, traffic management initiatives are put in place to ensure safe operations. And these are things like gate holes, ground stops, in-trail restrictions. We've all experienced these. I experienced them as an airline pilot. I experienced them as a passenger. And you experience them as a passenger also. But what that does is it keeps our system safe. Now, there's also a more permanent solution that the FAA has in place, and that is that they will reduce the number of flights in and out of airports on a more permanent basis. For example, 2 years ago, the FAA said to the airlines, you're going to have to cut schedules going into the New York area airports. They did that in summer of 23. They did that in summer of 24. And in fact, those restrictions will remain in place through at least October of this year and perhaps even longer. Now, currently, most air traffic controllers going to work for the FAA come through the FAA's training academy in Oklahoma City. The academy has a capacity of 1,800 students each year. However, each year of the 1,800, about 30% don't make it through training to enter the workforce. That's 600 controllers, potential controllers each year that don't make it through for whatever reason. And what our report did find is if the FAA continues this trajectory, when you factor in attrition and other retirement, other attrition, they will have a net increase of around 200 controllers between now and 2032.
Embry-Riddle has been a part of the Air Traffic Collegiate Training Initiative, since 1997. So we have hundreds of graduates of our program currently working in FAA air traffic control facilities across our country. Just last week, one of our graduates came for a visit, Nathan Forrest. He came down from Jacksonville Center. In less than a year, he's certified as a certified professional controller at Jacksonville Center. That may not mean much to you, but to me it means a lot, because it would typically take 3 to 5 years to achieve that standard. He did it in a year. And I take that as an example of the quality of our program here at Embry-Riddle. However, there's been a problem. The problem has been that as our students graduate and they apply for an air traffic CTI vacancy, it would take 1 to 2 years before they would get hired, meaning that they would have to get their medical clearance, their security clearance, before they can then become part of the workforce. That takes time. Now, with the Enhanced Air Traffic Collegiate Training Initiative, our students can get to work on that while they're still a student. So picture a freshman coming into our baccalaureate program. They can start immediately in their first year taking the Air Traffic Skills Assessment Test, which is the first requirement every controller has to meet prior to being hired. After that, then they can start working on getting their medical clearance. And then 12 months prior to graduation, they actively can apply for a vacancy in the Enhanced Air Traffic CTI program. And with that, they'll be able to get their security clearances. So by the time they graduate, they're ready. They can be immediately hired into the FAA. Bypassing the 3 to 4 months at the FAA Academy, completely eliminating that 1 to 2 year bureaucratic backlog.
We're going to take a break here on Florida Live, but we will be right back after this. Welcome back into Florida Live. I'm Garrett Wymer. Thanks for joining us. Governor Ron DeSantis was in Fort Pierce earlier today. He was talking about the state of Florida's economy and also announcing some grants from the Job Growth Grant Fund, awarding some money to colleges and county authorities for infrastructure improvements. During the question and answer portion, he was asked about Hope, Florida, ahead of another House Budget Subcommittee, House Healthcare Budget Subcommittee meeting tomorrow as they continue to probe into the funding and that $10 million contribution. So in his response to a question today, the governor continues to claim that the reporting, the details on this, is just partisan attacks on the governor and on the First Lady.
Yesterday, there was this fabricated report by some of these partisan outlets about the Agency for Healthcare Administration, one of our state agencies, doing a settlement with this company, Centene, who's one of the Medicaid providers. And they were told, hey, the agency is going to be releasing a letter with the documentation that kind of is going to explain this. And they went ahead and they published and they tried to, create and manufacture a narrative. Well, then what happens a few hours later? The agency puts out a document. It goes through the different agreement. The agreement they reached with the company was for about $56 million to recoup for this PBM Medicaid thing. It's there, it's documented. And then they got a $10 million private donation on top of that, which is what the agency said from the beginning. And so this is an attempt to try to manufacture a narrative where there's really nothing there. Why are they doing it? It's all because they want to try to impugn our Hope Florida program. That's why they're doing it. It's all political. And Hope Florida actually doesn't cost any money. It has been, and our First Lady led the charge on this. This was her kind of ingenuity that led to this, and said, okay, we've had for 60 years welfare programs that have had the effect of keeping people on programs, where a bureaucrat that's working in these agencies' job is to find as many programs as someone may qualify for and then sign them up. The problem with that is oftentimes that doesn't serve to be a true hand up that leads people on a pathway to self-sufficiency. At the same time, she recognized, and I think we all kind of get, that there's a lot of great resources in the state of Florida and throughout our country, but in the state of Florida, our churches, charities, businesses in the community that want to be impactful, even individual volunteers who will jump at the opportunity to make a difference in the lives of somebody who's in need. And so the Hope Florida insight is, let's transform the bureaucrats from trying to cut checks and put people on programs to being navigators, hope navigators, that will navigate the people in need to all the resources that will be available in the community. And so if you have a single mom who may have fallen on hard times, maybe needs a place to stay, those needs go into the Hope portal, and then the Hope partners, many of them which are religious institutions, but certainly not all, they then get it. And a lot of times you'll have a church come and help, or you'll have a charity come and help, or you'll have all these things. And so the net result of that is you've had 30,000 people which have gotten off means-tested welfare, and it's saved the taxpayers $100 million and likely to save over $1 billion over a 10-year period. That is a great success for the state of Florida. It's a success that other states are trying to emulate, and we have people make pilgrimages from other states to try to learn about it, but it didn't cost you anything as taxpayers. All it did was reimagine the proper role of government. We know government can't be all things to all people. That's failed. They did a war on poverty in the 1960s. If that had succeeded, we wouldn't have poverty. And yet it ended up entrenching a lot of this. So this is a better way. This is a better way for people in need. Their horizons will be expanded. They will do better. But it's also a better way for taxpayers. And so you look at some of the problems you see with the budget in Washington, this type of model would be better for people as well as save a lot of money. So that's what this is motivating. It's a political attack against the successful program and against the First Lady, because I think a lot of people are threatened by the success of the program. It upends some of their ideological commitments. It shows that she's actually made a difference. I know there's people that are threatened by that. So I think the Hope Florida program has been something that's been a tremendous success for the state. We want to continue to build off that, and we are going to be making announcements to do just that. So when you're over the target, people come at you, but this program has been successful, and I'm proud of all the good that it's done.
And again, we will be monitoring that hearing tomorrow, that subcommittee meeting tomorrow, as they continue to ask questions and probe. And I don't remember who, right off the top of my head, who all is supposed to be testifying tomorrow. But we will certainly have updates for you tomorrow, because we're going to be keeping a close eye on that in Tallahassee as the questions continue into to Hope, Florida, and things continue to kind of deepen with that. We're going to take another break here on Florida Live, but we'll be right back after this. Live look at Green Bay, Wisconsin and Lambeau Field, where the NFL draft is set to kick off tomorrow night with the first round. We've been going through all week this week and looking at the prospects of Florida's NFL teams and what needs they need to address in the coming draft. Today, it is time to look at the Tampa Bay Buccaneers. They have the 19th overall pick in the first round. And earlier, I caught up with Scott Reynolds, who's the vice president and publisher of the Pewter Report, to talk about what's next for the Bucs.
This is going to be a defensive-minded draft for Todd Bowles and Jason Light. They got to fix that side of the ball. Even though they signed Hassan Reddick in free agency and Yaya Diaby's an ascending player, they spent a second-round pick on Chris Braswell last year. If Todd Bowles wants to rush 4 and get pressure with 4, not have to blitz as much, well, then they're going to have to get another edge rusher. Donovan Ezeraku from Boston College is in the Pewter Report mock draft to the Buccaneers in the first round. 16.5 sacks last year. He's similar to Hassan Reddick in the way he can bend and use his agility to turn the corner and get to the quarterback. He would be a great understudy and a great rotational player in year one that might eventually replace Hassan Reddick. But don't rule out a defensive back either. Maxwell Hairston, the cornerback from Kentucky, Savon Ravel Jr. from East Carolina is another tall cornerback they could have an interest in. Or Malachi Starks from Georgia, who is a multi-dimensional player that can play nickel as well as safety.
Let's talk about that a little bit and some potential selections, some players that the Buccaneers maybe should target in this draft.
Well, to me, you have to look at the secondary. They're not happy with Jamel Dean's penchant for getting injured at the wrong time. Go back to that Detroit playoff loss in 2023. He wasn't on the field in the second half. Same thing last year in the playoff loss to the Commanders. Wasn't on the field in the second half. They can't count on him because of the oft-injured Jamel Dean's history of having those untimely injuries. So getting another starting caliber cornerback on this roster via the draft is a main priority for this team. And also finding a nickel corner. If you're going to move Tyke Smith from nickel to safety to replace Jordan Whitehead, you're going to have to come away with 2 cornerbacks in this draft. One more of an outside cornerback that might be longer and has some speed. Todd Bowles likes those kind of guys on the outside. Think Jamel Dean, think Zion McCollum. But then also getting a nickel corner, someone that can make as many plays as Tyke Smith made last year. And that's why Malachi Starks from Georgia might be an option in round 1.
Talk to us about how the strategy may change a little bit with the new offensive coordinator coming in. I know you said this is going to be a heavily defensive draft for Tampa Bay, but I'm curious if having that new kind of piece to the puzzle changes things at all.
Well, the offense won't change with Josh Grizzard's promotion, but Grizzard does want to put his own spin on things. He came from Miami, where he was the wide receivers coach down there, and he had 2 very fast wide receivers in Tyreek Hill and Jalen Waddle. So I think adding another speed receiver is something Tampa Bay wants to do. Don't rule out Matthew Golden from Texas. The Bucs have had him in for an official 30 visit. They had a formal interview with him at the Combine. They're very interested in Golden. I'm not saying they would pick him, but if the right defensive players were off the board already, they might consider adding a starting caliber wide receiver like Golden, who has 4.29 speed, to this team. Tampa Bay's offense has got plenty of guys that can catch the ball, but Mike Evans, Chris Godwin, and Jalen McMillan, not the fleetest of foot wide receivers. They can get the job done with the yards after catch, but having a guy with that level of speed could be a difference maker for this offense. And Mike Evans is in a contract year now. He won't play forever. Chris Godwin just signed for 3 years, but still coming off of that dislocated ankle. So wide receiver could be a position that they target, maybe not in the first round, but certainly on day 2 in the second or third round. Jalen Noel from Iowa State is a name to keep in mind. He ran a sub 4.4 time at the Combine and has really good speed as well.
Beyond just this draft, what else do the Buccaneers need to do in this offseason to kind of take a step forward next year?
I think the biggest thing is that they've got to train smarter and not necessarily harder, but they had so many injuries last year, especially on the defensive side of the ball, especially with hamstrings and soft tissue injuries. For whatever reason, this team was kind of snake bit, especially in the secondary. They've got to find a way to get all 53 guys that they're going to have on this roster to Sunday and have a healthier team. And, listen, the Florida conditions are brutal to train in with the heat and humidity. Hydration is always going to be an issue, but somehow, some way, the training staff has got to find a way, and working with the coaching staff, to not have so many players injured in practice. That was a big problem last year.
And that's an interesting point, because a lot of times we think about putting that roster together, having the right pieces in place, but it doesn't matter who's on the team if you're not on the field.
That's right. I mean, the greatest ability is availability, and we've seen this team, have some monumental games. Go back to that Chargers game, 40-17. They beat a playoff caliber team towards the end of the season. They went on a nice run, but they had a couple of slip ups in that Commanders game. I think getting a more talent on the defensive side of the ball is a big pressing need, but also finding a way to stay healthy. This team, when healthy, is a legit Super Bowl contender in 2025, certainly offensively. And if Todd Bowles can find a couple more key impact players for this team, look out. If Tampa Bay's defense can make some strides and get close to where the offense is, which is a top 5 unit, Tampa Bay could have a very, very good season ahead.
Well, that is certainly good news for many of you Buccaneers fans who may be watching us here on Fox Local Tampa. And if you are watching us on Fox Local Tampa, we are going to go ahead and wrap up here with our afternoon edition of Florida Live. If you're watching on Fox Local Orlando, though, we are going to keep with this Stephan Sterns hearing until our 4 o'clock hour. So let's go ahead and we'll go ahead and get you back inside the courtroom here in just a few seconds for as that hearing continues, that the detective still on the stand as the questions over evidence continue. So thanks for joining us.
When we were talking, or when we were looking at the video, yes, it was in my vehicle.
When did you turn over the phone to Detective Costa?
At the end of the night, after we secured the residence, which was around 1 in the morning, Detective Acosta was waiting for the tow truck for Stephan's Lincoln, and that's when I handed him the phone because he was going to Central Operations, and I was not.
Okay. Was that the last time that you had involvement with the phone?
Yes.
Okay. So after the handoff, nothing else, just to be clear.
In reference to, like, if I ever looked at the phone again?
Yeah.
Sure, I think it was like 2 days later.
Okay. So at that point, the phone's still in your law enforcement's possession?
Yes.
Confirm? Of course. No further questions.
Thank you. Redirect.
Defense mentioned that there were other law enforcement personnel that were at the apartment complex. During your interactions with Mr. Sterns, who was in the immediate area?
Just myself and Detective Acosta. Everybody was kind of just hanging out in the area.
Detective Tagler, I've got a question. When you initially interacted with Mr. Sterns, you indicated that you were going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
All right. Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? State?
No, Your Honor.
Defense? No. Thank you. Will the detective step down?
Yes, Your Honor.
Is Detective Tagler excused?
Yes, Your Honor.
Detective Tagler,
Thank
step
you.
down. Thank you. Mrs. Rep.
Yes, Your Honor. Detective Lewis Acosta.
Raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, and all you got?
Yes.
Will you please say your first and last name and spell both for the record?
Louis Acosta, Luisacosta.
How are you employed?
Orange County Sheriff's Office as a detective.
How long have you been with the Sheriff's Office?
5 years.
In February of 2024, what was your assignment?
I was a detective with the Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you become involved in the investigation of missing juvenile Maddie Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Sterns. Just, that basic information.
Did you also get information regarding LPR tag reader hits on Mr. Sterns' Lincoln?
Yes.
And you also got the timing of those tag reader hits?
Yes.
Did you respond along with Detective Tagler to 4012 Santa Maria Drive in Kissimmee?
Yes.
And did you learn any additional information prior to speaking with Mr. Sterns at that address?
Yes, prior we were briefed of Detective Hunt, who's the initial primary detective assigned, just of additional details. For example, that she slept in the same bed as Mr. Sterns, things like that.
Did you assist in the interview of Mr. Sterns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes.
And this would be on February 27th of 2024?
Yes, correct.
Where did this interview take place?
It took place in the parking lot of their of the apartment complex near the residence, Maddie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Sterns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity of where we were at.
How many law enforcement officials would you say were in the parking lot area of where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Sterns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this encounter?
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Sterns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Sterns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
if you asked a question, did Mr. Sterns respond in a way that was coherent?
Yes.
Did you have any difficulty communicating with Mr. Sterns?
No.
Did Mr. Sterns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Sterns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on the phone?
Mr. Sterns had the phone, and then he gave the phone to Detective Tagler after she asked, and he said yes.
Did Mr. Sterns have to do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing while Detective Tagler was viewing the content of the cell phone?
They were standing shoulder to shoulder next to each other.
Were you asking questions at that point?
Yes.
Were you able to see the content of Mr. Sterns' phone?
At some point.
Were you standing next to where Detective Tagler and Mr. Sterns were standing or somewhere else?
Yes, next to both of them.
Was Mr. Sterns facing the general area of where his cell phone was being displayed from?
Yes.
There is a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Sterns.
Do you continue to have a conversation with Mr. Sterns?
Yes.
At any point in time, does Mr. Sterns discuss the content of the cell phone or Detective Tagler's looking through the phone?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought out again?
Yes.
At this point, who had the cell phone?
Still Mr. Sterns.
When Detective Tagler asks for Mr. Sterns to unlock the cell phone again, does he do so?
Yes.
Does he have to enter the passcode again?
Yes.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr. Sterns' cell phone, correct?
Yes.
What information did you have together about the Maddie Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see her. There were many inconsistencies surrounding the time frame that he stated. He dropped her off and other things. And then the tag readers and information that we had about his movement.
Had the defendant been straightforward with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
Did you confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone when Detective Tagler checked that?
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you also present with Detective Tagler at the conclusion of this interview between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same.
Were they in the driver's seat or passenger seat?
Passenger seat, front passenger seat.
What about their appearance makes you believe that they were not awake?
Slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews?
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where there was a brief conversation. Did you have a brief conversation with the defendant about what was seen in Madeline Soto's phone?
Yes.
What did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as
she explained that we'd be taking the phone, be getting it back whenever the phone download was complete.
did Mr. Sterns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to this phone?
Yes.
And all of this is recorded, right?
Yes.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview, while Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to do like just some sort of update. There you go.
As a law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigations?
Yes.
When a cell phone is taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Sterns, that was audio recorded, right?
Yes.
Not video recorded?
No.
Okay. And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Sterns?
I did not.
Okay. When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search it, right?
Yes.
Okay. So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews. They had crime scene up.
Okay. At some point it got crime scene tape, though.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were kind of in one group, and then uniform patrol were kind of in the perimeter for scene security.
And while State asked you if you ever removed your firearm, I just want to clarify, you had your firearm on you, right?
Yes.
And you're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or?
Yep. On my hip, yep.
Yeah. So it's visible?
Yes.
And you said that while you're questioning, well, you and Detective Tagler were questioning Mr. Sterns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagler's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagler's taking a look at the phone. You're close enough to see the phone, right?
Yes.
Okay, so you can actually see what's happening on the screen?
Yes.
Okay. So it's not like when we're saying that you're standing around the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here. You're all grouped up together, right?
Correct.
Now, it was during that first interview that you learned that the phone was factory reset somehow, right?
Yes.
Okay. And when y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Sterns.
Okay. At the entirety of both first interview, second interview, everything, when you're taking the phone to the sheriff's office?
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
Okay. But between the first interview and the second interview with Mr. Sterns, it sounds like there's about maybe a 4-hour gap, right?
Yes, somewhere around there.
Somewhere around there. And at that point, you said that you went to the management to kind of take a look at the video surveillance, right?
Yes.
Okay. It'll take you 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing kind of next steps, things like that,
Right.
discussing the case.
So when you're saying debriefing, like, right, just you and Tagler, or are you talking to other people?
Other people, the unit,
Okay, so where does that happen?
in the management area.
Okay. So at that point, while you're debriefing, roughly how many law enforcement personnel are there?
I don't recall the number.
Can you remember anybody that was there off the top of your head? Sure.
Detective Tagler, myself, direct supervisors, so maybe a corporal and a sergeant.
Okay. So at least 2 other people present?
Yes.
And it's at this point, so that's where you all were talking to supervisors, right?
Yes.
And at that point, it sounds like one of the supervisors was like, hey, we need to go get that cell phone, right?
But yeah, I believe it came up during the conversation.
Okay. And then during that conversation, did anybody ever mention, hey, let's get a warrant to download that?
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
Okay. And did you ever ask Mr. Sterns if he could download the entirety of his phone?
I did. That conversation was had with Ms. Detective Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you ever attempt to draft a warrant of anything?
I did not.
For your phone, Mr. Cooper?
Sure.
Between the first interview and the second interview, you had never, neither you nor Tagler ever gave the phone back to Mr. Sterns, right?
Correct.
You held on to it the entire time?
Yes.
No further questions.
Did you conduct any interviews between the first and second interview with Mr. Sterns?
Yes.
Who else did you interview?
Jennifer Soto.
So that was also during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around a 4-hour, at the conclusion of the first interview, did you observe anyone direct Mr. Sterns that he could not leave?
No.
And when you returned after 4 hours, Mr. Sterns was where?
He was in the same parking lot area.
Any follow-up questions, Dave? Follow-up questions, defense?
Just one. During that time span between the two interviews, did anybody tell him that he could leave?
I don't recall that.
Thanks. May the detective step down?
Yes.
Is he excused from proceeding? Thank you, detective.
Thank you.
Additional witnesses are up.
Yes, Your Honor. Sergeant Darko Stamenic?
Please raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I did.
Will you please say your first and last name and spell both for the record?
Darko Stamenic, D-A-R-K-O, S-T-A-M-E-N-I-C.
How are you employed?
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensic squad?
since June of 2023.
What type of training have you undergone to perform some of your duties in the forensic team?
So going back to college at the University of Central Florida, I minored in IT. After that, I went to Cellbrite School, where I became a Cellbrite certified operator as well as Cellbrite certified physical analyst. Those are two certifications that we have to use some of the tools that we use. And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer forensic examiner certification as well.
Did you download any phones as part of the investigation into the disappearance of Maddie Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time that download was completed and viewable?
I believe around 5 o'clock in the afternoon.
That's a couple hours.
A couple hours, right?
Okay. So, can you explain how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any. Extract the data from the phone. Then we take that data, and we have another tool that parses that data, basically makes it readable by a human.
Is the time that it takes to extract the data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically with Madeline Soto's phone download, after it was completed, did you have the ability to share the data with other law enforcement officials that were working that same investigation?
Yes, I did.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field can view it.
Did you do that with Madeline Soto's cell phone the same day that
Yes.
you covered the data?
Yes, I did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Sterns' phone in this case?
Yes, I did.
Do you recall when you received
Yeah, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes.
So you waited for Detective Acosta to come from Kissimmee?
Correct.
What did you do upon receipt of the phone?
I began extracting the phone, and then I went home.
Sorry to interrupt. 2:28 at 3 a.m.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connect it to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after you plug the phone into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you arrived back?
Yes.
Was it completed?
It was.
Can you explain, for this particular phone, I believe it was a Samsung type phone?
Correct.
How do you factory reset it?
Yes, so you have to go into the settings of the phone. I believe this the next button says general settings, so you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset?
It is, yes.
Is this possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items are subsequently deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed up?
They do.
If a phone is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So, for example, the pictures, if pictures are backed up, the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
It has no further questions.
Thank you. Cross-examination.
Good afternoon.
So you're in charge of doing the forensic downloads on the phone?
Correct.
Okay. And when you're doing those forensic downloads, you said that there's a tool that you plug the phone into to fully download the phone, right?
Correct.
So it's not just downloading the information that's immediately accessible to the user, it's downloading everything, right?
Correct.
When it's doing that download, does it do a bit-by-bit copy of the entirety of that drive?
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a full file system extraction, so it's not a bit-by-bit copy.
Gotcha. So when it does that, though, if the phone's factory reset, you can still pull that information off the phone even though it's not immediately accessible to the user?
Like, I'm sorry, what?
The information prior to the factory reset.
Oh, no, not necessarily, no.
Okay, not necessarily, but in this case, you were able to pull information prior to the factory reset, right?
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud, and then it repopulated on the phone automatically after the reset.
Okay. Do you know at what time it repopulated?
It was, I believe, around 2 a.m. After the reset. I believe the reset was around midnight, and over the next couple of hours, the phone repopulated.
When you're saying 2 a.m., same day that you downloaded it or before?
No, it would have been when the phone was reset, and I don't want to speculate on the date.
Gotcha, no problem. When it comes to a phone being factory reset, are you on any kind of timeline to make sure to recover data?
Not really, no.
Okay, so that's not a concern to law enforcement, right?
No.
Okay, so once it's factory reset, it's factory reset, doesn't matter.
Right.
Your phone, of course. When you did the download of this phone, anybody give you a warrant alongside the phone?
No.
No, of course.
Read rec?
No.
Witness, step down.
Yes, sir.
Sergeant Stanek, excuse me.
Yes, sir.
Your Honor.
We're going to take a 5-minute recess.
This court is in a 5-minute recess. know sometimes I can get on a roll.
A little bit.
Just making sure. Yeah, exactly.
Oh, girl. Not great. I fake it. I fake it. Next time I might give you like a little. Yes. I wasn't prepared for you to expect me to stay there, like give me a call, give me a. It's okay. She needs a break. She just came in by you and she's like, go. No one. It's it. Hey. What's everything I've been trying to do? Nothing's gone. So like, I haven't really been having. Yeah, just hanging out. Well, you made it.
Please come to order. The circuit court is back in session. The Honorable Chief Carson presiding. Thank you.
Your Honor, let's seek some clarification from the court as to whether we're going through all three motions today or just the first two that we're going over, because the state's position is that the burden is substantially different for the challenge to the warrant.
Understood. Do you believe that you have presented the witnesses for the first two motions?
If the first two motions are the seizure motion and the consensual search motion, yes.
Thank you. Defense, in your motion as to the motion to suppress evidence obtained from the Google search warrant, there was some argument that the defense does not have the burden or has satisfied its burden. I'll entertain argument as to that.
May I brief?
Sure.
When it comes to the burden for attacking the warrant itself, the primary basis for the state's argument is based on four corners of the warrant affidavit. So when it comes to the burden itself, it would be, we would be arguing that it's satisfied at least for our arguments we heard at this point, considering that we're challenging the actual document itself.
Understood. So, did you anticipate presenting witnesses or evidence in support of that motion?
No.
Okay. So you were just going to present argument?
Yes. Based on, right now we have the chain of how the warrant came about, and then getting to the cell phone download, and then there's the warrant itself.
Okay. So you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
And rely on the evidence that's been adduced in cross-examination to support the probable cause, or the lack of probable cause for the...
Exactly.
Does that give the state any clarity?
No, Your Honor. Florida Rule of Criminal Procedure 3.190 subsection G3 specifically states if the court hears the motion on its merits, the defense shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence. That the defense's burden is to show that there's grounds for suppression of the warrant. I don't believe that that burden has been met for the state to be required to present rebuttal evidence. The affidavit is not before Your Honor.
Understood. All right, so as to sufficiency of the warrant, what evidence does the court have to make some determinations as to the sufficiency of the warrant? Talking about the technical defects that are alleged in the motion.
Yes, Your Honor. At this point, it's actually part of the court file, so we'd be asking not to judicial notice of the search warrant.
It's not part of the court file. Search warrants are not part of the court file.
Absent some affirmative presentation of evidence regarding the argument, there is some kind of technical deficiency that makes the search warrant of the Google activity unlawful. It's going to be hard pressed to make a determination as to that. Let me ask the state. Are you requiring the defense to recall the witnesses that have just testified, or if they can find their argument to information that was elicited either in direct on cross, does that satisfy their burden, or shall we go through that entire exercise again?
I have a vote.
Sure.
Your Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However, there is no information before the court about the Google search warrant at this point. So the state's position is that they have not met their burden pursuant to the Florida Rules of Criminal Procedure to shift, to require the state to present rebuttal evidence at this point.
Additional testimony, the court's going to rely on the testimony that's been provided. There was a cross-examination and a redirect. That information is in the record. The defense can make argument that satisfies their burden or not. Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
The defense makes argument that the Google warrant relied on illegally obtained evidence and that there was no attenuation or intervening circumstances that purged the taint. The court has heard testimony from the investigating detectives that challenges the legality of both the search and seizure. That appears to be what the challenge on the warrant refers to, and that it is invalid as fruit of those illegal searches. As far as the application failing to establish probable cause, the court does not have the application. As far as the legal standard, probable cause in digital search warrants, the court is uncertain what kind of warrant this was or whether it was a digital search warrant. The argument that it fails to establish the sufficient nexus between the Google account and criminal activity, I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language, again, we have no evidence to support that argument. The temporal scope of the court would have no evidence to support that argument, and peculiarity for digital searches. Without additional information, the court would find that there's no evidence to support that argument. As to the evidence supporting the arguments that the search warrant is invalid based on lack of probable cause, based on reliance on illegally obtained evidence of intervening circumstances purging that taint, and being invalid as fruit of an illegal search and seizure. I think that evidence has been reduced in combination with the first two motions. So as to those issues, the court will find that if there's been record evidence that supports that argument.
Given the hour at this point, defense will be asking if we can bifurcate the first two motions from third. Given the
These three motions were set together, and we're going to address all three.
Given the court's ruling, the state will call its next witness, Detective Taylor Howard.
You're watching Fox 35 News Plus, streaming on Fox Local.
Well, good afternoon to you and welcome into Fox 35 News Plus. I'm Garrett Wymer and thanks for joining us on this Wednesday afternoon. You've been watching here on Fox Local and on YouTube this evidence suppression hearing in the case against Stephan Sterns as the defense is trying to get thrown out some evidence from the phone of Stephan Sterns and the Google account as well of Stephan Sterns. He is charged with dozens of counts in this sexual battery case against him in connection with 13-year-old Maddie Soto, who disappeared and was later found dead. He is also charged with capital murder in that case. We will talk more about that in just a moment because it is 4 o'clock, and that means it is time for today's Top 4 at 4, where we break down 4 of the big stories that we're tracking in the Fox 35 newsroom this afternoon. And joining me for today's Top 4 at 4, Fox 35 news anchor and reporter Marlisa Goldsmith. And Marlisa, we appreciate you joining us this afternoon.
Absolutely. My pleasure, Garrett.
So we want to start here with an update from Tallahassee, where we learned that a funeral has been set for one of the shooting victims from last week's shooting at Florida State University.
Yeah, we actually just got a press release about this today from the family, but a funeral has been set for Tiru Chaba. He's one of the 2 men who were killed in the Florida State University mass shooting that happened last week. The funeral is going to be held at 10 a.m. on Friday in Greenville, South Carolina. And the 2 people that I just mentioned that were killed have been identified as Mr. Chaba and 57-year-old Robert Morales, who worked there on campus in the food services department. There are 6 others who were injured in the shooting that happened on April 17th at FSU, including the alleged gunman, which is 20-year-old Phoenix Eichner.
And today in Tallahassee, there was a very emotional tribute made by the State Senator Corey Simon, who lives in and represents Tallahassee. And he broke down during, and I want to play about a minute and a half of a clip as he speaks and tries to speak to honor the victims on the Senate floor. Let's listen.
Last Thursday, my FSU family I knew this day was coming, and was rocked by senseless violence on our campus, with 6 students being shot and 2 adults being killed. Today I rise and ask for a moment of silence for my Seminole family as we mourn those lost and the many lives that have been changed forever.
Please rise in a moment of silence and remember to those that were lost in this tragedy.
And so then they held that moment of silence. You can see members of the FSU community in the gallery. Some more were also recognized after that moment of silence as well, including some students who were FSU students and also were students at Marjorie Stoneman Douglas back in 2018 on Valentine's Day when that shooting took place. But you saw emotional moments, emotional words there, and then lawmakers from across the aisle a bipartisan show of support going over and patting him on the back, consoling him, giving him a hug. The Senate went into recess for a few minutes. The Senate president stepped down from the dais and went over there as well. And then when he kind of came back, the Senate president addressed the gallery and said, "This is the best of the Senate." So, nice to see them showing support in what has been an emotional time for many in that community.
Yeah, for a lot of them. And it's interesting because obviously a lot of these lawmakers, they live in different parts of the state, right? So they may just be up in Tallahassee for the session or for legal matters. But when it comes to, or legislative matters, I should say, but then they go back home. But for him, he represents that area. I'm sure he's constantly on FSU's campus. I'm sure he knows some of the students who go there by name, who knows their family. So it's somewhat of a deeper connection than maybe some of the other legislators that are up there with him. Or, just there temporarily, I should say. Yeah. You can tell it touched him.
In a lot, yes, very much so. Now, our second story today, and we will go ahead, let me give you, actually I'll pull up this video here of Stephan Sterns entering the courtroom as this suppression hearing begins. Trying to get some evidence tossed. This hearing is still going on right now. It does look like they took a little bit of a break that they were kind of referring to at the beginning of our show, but they're still going to begin, it sounds like, call more witnesses in this hearing.
Yeah, so there is evidence that Stephan Sterns and his legal team want tossed in court. Just to catch everyone up to speed here, just again, a reminder, Stephan Sterns is the man accused of raping and murdering 13-year-old Maddie Soto. He appeared in court Tuesday morning. And this hearing came before today's scheduled suppression hearing that Garrett was just mentioning, in which Sterns and his attorney was looking to delay, citing newly obtained confidential information according to court records. Now, the defense was hoping to prevent jurors from being able to see that evidence from Sterns' phone, his Google account, which they claim was unlawfully obtained, though prosecutors argue he gave consent. However, at the hearing yesterday, the judge denied Sterns' request for the delay, which is why you were seeing video at the top of the show here at top 4 at 4, showing that hearing happening right now. We are trying our best to keep tabs on what's going on inside the courtroom, and we'll be sure to bring you the latest when we learn more.
Yeah, here's a live look right now. Nothing going on at the moment. They are in a bit of a recess, it appears. So yeah, we'll keep monitoring this. But we did earlier also hear from Stephan Sterns, who testified in this, because the main question is whether this information from his cell phone, from his Google account, was obtained lawfully and with consent, whether he knew what was happening. Right. And so here's a little bit of what he said when he was questioned by his attorney at this hearing just a little bit ago.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right, can you please state and spell your last name for the record?
Stephan Sterns, Stearns.
And Mr. Sterns, did you come into contact with law enforcement in February of 2024?
I did.
During your contact with law enforcement, did they seize or take an item from you?
Yes, they did.
What item was that?
That would be my cell phone.
Do you know what type of cell phone it was?
It was a Samsung Galaxy, I believe it was a 24.
And what was your understanding, if any, as to what they were going to do with it?
They were just going to check my Google Maps and check to see if I was logged into Google, and that was it. That was all I agreed to.
Were you shown, or did they have a warrant?
They did not.
No further questions, sir.
And so something to watch, because obviously this is key evidence, and we will see what the judge ends up ruling on this. We've seen a number of witnesses called today, not just Stephan Sterns testifying, but detectives, other investigators with the sheriff's office talking about it as well.
Yeah.
Story number 3, and this one's getting a lot of attention online, Marlisa.
Garrett, when you think you've heard it all, just wait, because Florida is going to prove you wrong. This story is one that a lot of people are talking about. They're clicking on our website on fox35orlando.com. A Florida woman is facing several charges after she impersonated a U.S. Immigration and Customs Enforcement agent, also known as an ICE agent, and kidnapped her ex-boyfriend's wife from her job, according to Bay County Sheriff's deputies. So the victim says that they believe the suspect, this person you're looking at right here, LaTrance Battle, was an ICE agent as she was in the process of becoming a legal United States resident. And deputies say that LaTrance Battle showed up wearing a black shirt with ICE printed on the front, had a sheriff's office business card with her, and even a handheld radio. But the victim became a little suspicious after Battle took her to an apartment complex instead of the sheriff's office. Now, this woman you see in handcuffs is facing many charges and has been ordered by a judge to have no contact with that victim, Garrett.
That is a bizarre story.
So bizarre. I mean, she really thought she was playing the part.
Yeah.
With a shirt that said ICE on
Definitely.
it, a handheld radio.
Yeah, definitely went to some lengths to show that, at least, according to what investigators are saying.
Yeah, it'll be interesting to hear maybe motive when it comes to this. Obviously, this is an ex of hers, the ex's wife. So who knows her reasoning or motive behind why she decided to do what she did today, but very interesting.
Let's go on to story number 4 here, and this is a very Florida story and a very American story, all in one.
Yeah, a Lakewood ranch man said that he dived into a lake without any hesitation to rescue a wounded eagle on Saturday when it fell into the lake in his backyard. There's a look right there at the man who jumped in with no hesitation. The bird was injured during a fight with another eagle, allegedly. And the wounded eagle is stable, we've learned, but has a long road to recovery, according to the Wildlife Center of Southwest Florida. But, I mean, look at that. Just imagine being in your backyard, you see that. That's some bravery right there.
It really is, and especially because apparently what he said was he knows there's a 7-foot alligator that lives in that lake.
Yeah, it's infested.
Yeah, and still jumped in, wasn't even thinking about it. Here's why he said he jumped in and did it.
That would be in my head the rest of my life, I couldn't save this bird, so I had to do it. I just wanted to get the eagle and save it, because it's our national symbol, it's freedom, it's America,
Yeah, so he did it for America.
A true American.
That's right, a
right
hero.
Here in Florida.
I tell you what, he is braver than I would be to jump in.
You and I both.
It'd be one thing if it were a swimming pool or something like that, but for him to jump in a lake where he knows there are gators.
Now, I will say, I may have
brave.
gotten some rope and, toss the rope to the bird. Come on.
Yeah.
Try your best. I know you're injured, but let's rally here.
Right, you just really needed to grab on with its beak.
Something. And I would have gotten on the phone, too. That's help. That counts.
Yes, that is true. That is true.
counts.
That helps. We can all pitch in different ways sometimes.
In different ways.
Yes.
But kudos to him for helping and not having any fear there.
I know. How about it? Well, that is a good way to wrap up today's Top 4 at 4. Marlisa, thanks for joining us. We're going to take a break here on Fox 35 News Plus, but we'll be right back.
You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I want to get you back inside this courthouse, the courtroom rather, in Osceola County, where attorneys are giving their closing arguments in this suppression hearing. The defense trying to get some evidence thrown out. They are now discussing, giving their final arguments to the judge as to why. Let's go ahead and listen in.
The seizure of the phone. There was no warrant ever sought. There's no warrant that was presented. This was, again, unilateral action, even though there's been an emergency judge ready to go on duty since the 80s in the 9th Judicial Circuit, both for Orange and Osceola counties, for law enforcement to seek a warrant, and yet they chose not to. When it comes to any other potential claimed exceptions, such as the emergency aid exception, it was clear from the detectives that looking through the phone, the seizure of the phone, this was in order to further investigatory purposes. This was not a situation where they were seeking to render any emergency aid. The community caretaking exception to the warrant requirement absolutely doesn't come into play. The phone posed no danger. There was no community protection purpose. This was purely an investigative seizure. As to the attenuation for this warrant, or for the seizure, there is no attenuation from the moment that Detective Tagler took possession of that phone, handed it off to Detective Acosta, and then handed it off to the Osceola, or the Orange County Sheriff's Office, I apologize. There were no intervening circumstances, and this was one continuous chain of possession by law enforcement. So, essentially the seizure, Your Honor, there's no warrant that's been sought, there's no exigent circumstance that allows law enforcement to collect this beyond the mere claim that they could just unilaterally take it. So for the seizure itself, we would argue that that's going to support.
Thank you. State, would you like to reply on a motion by motion basis? That'd be helpful.
In the meantime, I know the defense cited some of the case law from their motion. I did have the opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct site or a copy of the case, I would appreciate it. I could not find Appellate v. State, the site that you cite. I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable. Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on a USB organized by motion so that it was easier to be accessible rather than providing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is. Exigent circumstances, there's also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. v. Babcock, State v. Darter. The state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances.
The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone, but he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers placed the phone in airplane mode to prevent that seeking. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began populating on the phone. And that's the 2 a.m. population that Sergeant Stamanik mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction of evidence. There was also testimony that even though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard. Probable cause plus exigency. Everything that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and going to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in this particular hearing. There are multiple inconsistencies. All of these things lead to probable cause and exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead and take my phone. The law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they secured probable cause. That's not the standard here because the state's relying on the probable cause plus the exigency to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-prong analysis as to probable cause and the exigency, again, when it comes to the exigency, the direct testimony that was elicited during the hearing is that to law enforcement, there is no exigency at the point that the phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Acosta, the detectives on scene, were thinking as to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that makes sense. Moving on to the second motion, if Your Honor's ready.
Johnson, I'm ready.
Yes, Your Honor. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant search of the phone. There's no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Sterns, had indicated, yeah, that's fine. When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" and Mr. Sterns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to navigate through the rest of the phone, through additional screens, not consent to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Sterns agrees, but again, this is, limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Sterns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search call the search of the call history in this case. So that is completely outside the scope of the searching of the maps, the history photo, or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Sterns' freedom to leave. While the state is going to argue that he was free to leave, and the detectives stated that he was free to leave, no statement was ever made to Mr. Sterns that he was able to leave the scene at any time. Instead, what happened is that...
Is that required, or is that a factor to be considered?
It's a factor to be considered. And when considering that factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Sterns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has the scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Sterns feeling that he was not free to leave. When we're looking to any potential course of police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Sterns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent anymore. So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Sterns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent is limited. And while the detectives and the state want to argue that, well, he stood right there and never said no, Your Honor, some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for him. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Sterns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Sterns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation. When we're looking to the actual physical state of Mr. Sterns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. We know law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process. When we look to the standards here again, it's not what law enforcement believes that Mr. Sterns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of, you can either consent or we can get a warrant. At that point, Mr. Sterns' ability to consent has been tainted, it's been coerced, and for that reason we would argue that all of the searches of the phone violate the Fourth and Article 1 section.
Thank you. Ready?
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court is that the defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of Ms. Soto's vehicle. There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and law enforcement? You have Detective Tagler, after speaking with the defendant and him being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is, this conversation happens, the detective is looking at the defendant's phone. Subsequently, the detective looks at the defendant's call history. And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acosta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. There's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
Is this information that she had prior to giving the phone back, correct?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter, but it could have been before. My position, the state's position, is it's during this time frame where she's asking.
The argument of the state was that she asked to take a picture of the history, looks at the call history.
She takes a because it's what a reasonable person would understand the interaction is going to be. My position is that she uses general term history, and then she eventually goes into the call history.
Is that in the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument? Is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone, because she asks him to unlock the phone. They have a conversation. She brings up that the call log. She said, I also noticed, I was checking your call history. I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's when the discussion about the
factory reset
occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
The probable cause.
Yes, yes.
Sorry, I didn't mean to misdirect you.
So it's at that point that there's a seizure. There's some other information that's ascertained by law enforcement, and then they do a second interview with Mr. Sterns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent to forensically download the phone. It's not very long after their initial introductions on the audio recording. She says, I told you I was going to hold on to the phone. We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that that statement is phrased, it is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent. If the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement was seeking a complete download and to go through the entirety of the phone by the way that that conversation is had. Because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had and the lack of coercion by law enforcement towards it. In fact, the defendant was actually free to leave and did leave the apartment complex after this second interview. He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle. That goes to any coercive nature argued by the defense. The state also relies on the same factors as permitted by case law. Whether or not the defendant was free to leave, whether there was any coercive police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's...
I think as fast as I type, so I was with you up to extent of cooperation.
Or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and the defendant's belief that no incriminating evidence would be found. All of these factors should be considered by the court in determining the defendant's voluntariness of consent. So the state has to show that the consent was voluntary by clear and convincing evidence, and the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard for consent is whether it was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent. So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And they communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone. He could have said no. There was a lot of testimony that he was free to leave and he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Maddie Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is that the consensual searches that were conducted in this case were valid and permissible under the Fourth Amendment.
Thank you. Brief rebuttal.
As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation. Here, while we don't have
All right, so you've been listening to and watching this suppression hearing in Osceola County. It appears we just lost our feed as those arguments are continuing through the different motions there about whether this was a lawful or unlawful search and seizure of Stephan Sterns' cell phone. And I'm trying to keep an eye on these feeds to see if we have anything there, but it appears that we do not. So You heard some of the arguments there from the prosecution. Well, let me start here. You heard some arguments from the defense saying that this was unlawful because there was no warrant, there was no consent. They said the investigators took a unilateral action and an unlawful search and seizure. The prosecution saying this, yes, was a warrantless seizure, but that they had probable cause and also some, in the legal speak, exigent circumstances, and they walked through a number of those things as well. Well, we're going to take a break here on Fox 35 News Plus, but we'll be right back.
Check. You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us on this Wednesday afternoon. I want to show you some video from Palm Bay where two brush fires broke out this afternoon. Palm Bay Fire says one of them was in the southwest corner of Babcock Street and Malabar Road. Fully contained, though. The other is near the railroad tracks behind Onyx Drive. We know a number of homes had to be evacuated, and officials believe the fire started there, the Onyx Drive one, with a car fire and then spread to nearby brush. Fox 35's Esther Bauer spoke to Palm Bay Police.
Two brush fires sparked around the same time. Speak with us what you all are working.
Yeah, so the fire behind me was started from, actually it came in from a vehicle fire in the area, and the vehicle fire spread to some nearby bush. Bush caught onto some of the trees, and then the trees just started giving the fire an opportunity to run as far as it wanted to. So it ran along this canal, kind of unabated for a while, and then it came close to the canal and started jumping the canal, which put all the homes behind us here in danger. So the other fire that came in almost simultaneously to this one was actually called in by one of the units that was responding to this fire. So it didn't even come in with a 911 call. So, you know, I've been emphasizing to the community that if they see something, they want to make sure that they call 911 so we know that there's actually an emergency, and let us decide whether or not it's been handled yet or not, and we'll do the rest.
About how many homes on the street had to leave?
Yeah, so there's about 20 homes along this road right here. We're saying we have evacuated probably about 12 of them, and that was just purely just to be sure that everything was okay. It did encroach on some of the property lines here. A couple of fences did catch on fire, but luckily everything stayed away from the homes. We had crews with hose lines in between all of the homes, just making sure that we could protect the property the best that we could, and we did a pretty good job.
Did this, well, yeah, because no properties were lost.
Yep.
Yeah. Did this canal help that it it kind of stopped it.
Yeah, so it's kind of a natural fire break, which is wonderful to us, but regardless, that the wind was blowing off the coast, so it's kind of blowing this fire towards the homes. So had this not been here, we might be having a different conversation. So it did buy us a little bit of time, enough time for us to get units into place so that we could deploy them and make sure everything that stayed, make sure the fire stayed off of the houses.
About how many acres burned in this fire?
So I haven't been around this fire yet, but I'm going to say it's probably about 10 acres. But again, it stretches all the way to the railroad tracks and beyond that, and then it goes north and south, along this canal line for quite a bit.
Was it US 1 car fire?
It was a US 1 car fire, which is where this all started, and then just because of where the fire was, it was really, really difficult for first responder access to get to it. So the fire would sort of grew without any water on it because we just simply couldn't get to it.
And the other one, y'all are investigating maybe a homeless camp situation?
That is what I'm told. I can't confirm that, but we have had repeated fires in that area over the last 2 or 3 days. And with the conditions being as dry as they are, it's impossible to be okay with the use of open flame and discarded incendiary sources, because it literally takes nothing for a fire, especially in these conditions, to grow and get out of control.
And last question, what is your message to viewers to take this weather seriously? You guys stopped this, but this could have been really bad.
Yeah, it doesn't. You don't really understand how important it is until you see the fire when it gets this close to homes. When it's out in the compound, when there's nothing really around, it feels a little bit differently. But for this, everybody's just got to be really, really careful. If they live along where there's a lot of forest and trees, trim back your lot lines, make sure everything stays nice and tidy, clear the debris from your homes. And again, if you see something, call it in. Let us decide whether or not it's been handled or if we know about it yet. More than likely, we'll have units coming, and just be vigilant. Watch out for one another, because you just never know how these fires are going to start up and how fast they actually do run.
Will you be out here for some time still doing hotspot checks?
Yeah, oh yeah, we'll be out here for several hours at both locations. We'll be out here for several hours.
So that's the story we are continuing to monitor as we get ready to hand things off to Fox 35 News at 5. Which is beginning. We know Fox 35's Esther Bauer is out on this scene. She'll have updates on it and more details. I know she's been speaking to folks in that area that have been evacuated and affected by this, continuing to watch that situation. So we'll have new details on that coming up in just a couple of minutes here on Fox 35 News at 5. Fox 35's Randy Hildreth has been inside the courtroom all afternoon for the Stephan Sterns suppression hearing. She's going to get us caught up on all of that, including what we heard from Stephan Sterns earlier today, testifying about not giving consent for the search and seizure of his cell phone, something that was discussed, as well as the lack of a warrant. So we are continuing to monitor that hearing, as well as our time here on Fox 35 News Plus comes to an end. So it's been a busy day. We know there's still a lot to come, and so we appreciate you joining us here. We will go ahead and send things out to Studio A, where John and Luann are getting ready for the start of Fox 35 News at 5 and tracking some breaking news as well. We appreciate you joining us here at Fox 35 News Plus. We're here weekdays 11 a.m., 2 p.m., and 4 p.m. with live hours of Fox 35 News Plus and Florida Live, and any other time as news warrants. So you can keep it on Fox Local here, because the news never stops, and Fox 35 News at 5, getting ready to begin in just a second. So have a great rest of your Wednesday. We'll see you back here at 11 a.m. with more Fox 35 News Plus. But in the meantime, we will send it out for the start of Fox 35 News at 5.